Hello and welcome to another vlog from the Clinical Negligence Group at No5 Chambers. I am joined today by the wonderful Esther Gamble, who is going to chat to us about secondary victims. We have already done a vlog on this subject, which we recorded a few weeks ago and put up. So I would encourage anyone watching this to go back and look at that. It's quite a generalist view of this type of claim, which was sort of an immediate reaction to the decision in Paul. Esther is joining us because she has a very exciting case in the pipeline, which is along the same lines as Paul, but also throws up some new issues as well. So thank you very much for joining us today, Esther. Very happy to have you here. So first of all, would you like to give us a rundown? Obviously, this is a live case, so we can't talk about specifics, but sort of some general issues that are arising in your case from the facts.
Yeah, absolutely. So in my case has been, we've had one decision on it already, a first instance decision, and it is reported on Lawtel, so it is out in the public domain. It's the case of Purchase and Ahmed. And as with all of these secondary victim claims, the facts are absolutely tragic. My client's daughter was not very well. She wasn't terribly ill. She went along to see her GP with her mum in tow, and they saw her GP. Her GP wasn't particularly concerned about her, it seems, and essentially she had pneumonia, but he didn't pick up on this and didn't send her off to hospital for further investigations. And it's alleged that that consultation was negligent, essentially, that he was in breach of his duty to her. She went home, she stayed ill, didn't particularly get any worse, didn't get any better. And 2 nights later, very suddenly, she passed away in the night in the most horrifying circumstances. And her mum found her and, as you can imagine, was beyond distraught and went on to develop a psychiatric illness as a result. And so that leaves her as a secondary victim to the tort that we say was committed by the doctor in the first place. So those are the facts of my case. And as I say, all of these cases are absolutely tragic, but they are facts that the courts have to grapple with repeatedly to try and give sensible decisions in order to give compensation where it ought to be given.
I mean, they're awful circumstances, sort of compounded by the fact that the law in this area is sort of unclear or hanging in the balance at the moment with the recent decisions in Paul. I think one of the really interesting issues that Paul raises, and also your case raises, is the difference between factual and legal proximity. Could you just explain sort of the difference between the two? Because I think sometimes we use them interchangeably, but that's probably not quite right.
Yeah, absolutely. So in the last vlog, you guys discussed the control mechanisms which were laid down in the case of Alcock arising out of the Hillsborough litigation, which set out criteria that claimants have to meet in order to successfully recover compensation as secondary victims. And one of those control mechanisms is that there has to be proximity in space and time to the event. And one of the things that we're going to discuss during the course of this vlog is what is meant by the event. So that's factual proximity. The person has to be a bystander, essentially, or they need to witness what has happened or come across the aftermath of it very shortly thereafter. So they have factual proximity to the event. Legal proximity is the need for there to be some sort of a relationship between the tortfeasor and the person claiming compensation. And this is a notional construct, really, that the courts have said it's fair to impose liability on a tortfeasor where there is legal proximity. If there isn't legal proximity, then essentially it's too remote and the tortfeasor shouldn't be liable for it. Now, with secondary victim cases, the courts have put together the control mechanisms as a way of satisfying the requirement for legal proximity. So if somebody satisfies the control mechanisms, including factual proximity, then as a matter of law, they have legal proximity to the tortfeasor. So there isn't a separate requirement for legal proximity. Legal proximity is made out by satisfying those control mechanisms.
All right, thanks very much for that. That's cleared everything up, I hope. So in terms of, I suppose, moving on to what this event is, there's sort of tension in the case law. And I suppose one of the sources of that tension is that this idea of a secondary victim claim in a clinical negligence case is slightly different to a personal injury case, isn't it? So why is that?
So that comes down to this idea of the event. So the control mechanisms say that a secondary victim has to have proximity in time and space to the event. And they also say that the secondary victim has to develop a psychiatric illness as a result of witnessing a horrifying event. So we've got that word event again. Now, most of the cases involving secondary victims arise out of accidents. And so your classic accident, there is a very clear event. The event is the accident. And in a lot of the reported cases, the words event and accident are used entirely interchangeably with no thought as to whether they might mean different things. Now, in clinical negligence cases, of course, you don't have an accident. You have a decision by a doctor, or sometimes a failure to make a decision by a doctor. So it might be giving advice, it might be failing to make a referral, it might be failing to arrange investigations or treatment, or it could be a mistake during the course of an operation. So you have a breach of duty, and then you can have the consequences of that breach of duty, which sometimes are immediate, but very often are further down the line, days, weeks, or months further down the line. So there's nothing there that can be described properly as an accident. And in terms of what the event is, there is a tension between, well, is it the breach of duty that's committed by the doctor, or is it the consequences of the breach of duty? So if somebody then suddenly deteriorates and dies days or weeks or months later, is that the event, or is the original breach of duty the event? And that's where the courts have really struggled to get to grips with how those control mechanisms should be applied in clinical negligence cases, and where there hasn't been any clarity at all from the courts until the appellate decision in Paul and Wolverhampton very recently.
Yeah, so I suppose what we're looking for is a transferring of an idea from personal injury to clinical negligence, and what's kind of the ideal scenario of what we class the event as when we're applying it in clinical negligence cases.
That's absolutely right. Yeah, that clearly the same terminology doesn't just lift across from accident cases to clinical negligence cases, and that's something the courts just haven't got to grips with until that appellate decision, which was very, very welcome. So the Paul decision is going to appeal, potentially. The defendant has sought permission to appeal from the Court of Appeal, and everyone's waiting at the moment to find out if the Court of Appeal are going to give permission or not. So it may be that the Paul decision by the High Court stands, and then that will be the state of control mechanisms as they apply in clinical negligence cases moving forwards. Or it may be that permission is given to appeal, and then we'll have to wait and see. And so my case at the moment is pretty much on pause while we're waiting to see whether permission is granted in the Paul case. If permission is granted in the Paul case, then there is a reasonable likelihood that mine will be joined with Paul and go straight to the Court of Appeal for the court to consider both of them at the same time, enabling them to give even greater clarity about the law in this area.
Yeah, well, I suppose clarity would be very welcome. I think one of the cases which I suppose in personal injury terms proves a problem for secondary victims is the case of Taylor and Anovo. And one of the things that talks about is a breach having two consequences. So firstly, in that case, because it was an employment liability case, there were some injuries to the claimant, so fairly minor injuries to her head and to her arm as well, I think. And then followed some time later by her death. Is that something which applies to your case? Because obviously Taylor found that essentially that one had to be present at both of those occasions in order to be a sort of a secondary victim who makes out their claim. Should that be the case in clinical negligence as well?
So the case of Taylor and Anovo is the one that has been heavily relied on by defendants in resisting secondary victim claims arising out of clinical negligence. But to my mind, that displays a real lack of understanding of the nuance of the case. In Taylor and Anovo, as you say, it was an accident at work. So there was an accident there. So it fits the control mechanisms very neatly. Unusually for an accident, there were some unexpected longer term consequences. So as you say, the lady unfortunately injured her foot and her head initially, and she seemed to be recovering well. And then 3 weeks later, she developed a pulmonary embolism, and she very sadly collapsed and died as a result of that, witnessed by her daughter. And the court's concern in that case, the reason that the claim failed, the court said there was one event, which was the accident, which had two consequences, the initial injuries and then the later collapse and her very, very sad death. And so the court specifically found that the event was the accident, which is absolutely what you would expect looking at the control mechanisms, because all of the cases relating to accident cases use event and accident interchangeably. So it would be very, very strange to have an accident case where the court said, well, whilst there's been an accident, we're actually going to focus on something entirely different for the purpose of satisfying the control mechanisms. So it's not very surprising that Taylor and Anovo failed, but those same considerations simply don't apply in clinical negligence cases, because you do not have an accident in clinical negligence cases. So the court didn't say that the claimant had to be present at the breach of duty. The court said that the claimant had to have been present at the accident. And that's the key difference here. So one accident, two consequences, whereas in clinical negligence cases, you have no accident, and in the classic clinical negligence secondary victim claim, one consequence, which is the sudden demise of the loved one. So the two are not on all fours at all, and it's quite surprising that defendants have clung on to the judgment in Taylor and Anovo as strongly as they have, when it's so demonstrably very, very different and easily distinguishable.
I suppose that's why you would be looking towards the decision in Walters instead as another clinical negligence claim, and possibly you would say, I suppose, more on all fours with your case in terms of both the facts and sort of the legal considerations as well.
That's absolutely right. So in Walters, again, a very, very sad case where a little baby grew ill and was taken to hospital by his parents, and the hospital negligently failed to diagnose his illness. And so he didn't receive the treatment that he needed. And he stayed in hospital, and 2 or 3 weeks later, he fairly suddenly and unexpectedly grew very, very, very ill and very quickly deteriorated and passed away in his mother's arms. So in that case, again, there was that delay between the breach of duty and the very devastating consequences of that breach of duty. And that case succeeded in the Court of Appeal. So it's difficult to see how that can be reconciled with an argument that a separation of breach of duty and the consequences of that breach of duty are fatal to a secondary victim claim.
All right, so I think one of the issues which is slightly different between Paul and your case is that in Paul there's a fairly lengthy delay, I think, between the initial negligence and what we would say is the event. There's about 14 months between those two. Whereas I think your case, everything happens a lot more quickly, doesn't it?
Yes, that's right. So in Paul, as you say, it was 14 months from when Mr. Paul had originally gone to the hospital and allegedly not received the treatment he should have received, and when he very sadly passed away at that later stage. Whereas in my case, it's just over 2 days, it's about 56 hours that passed. And I think the length of the delay is something that weighs on the court quite heavily, and is a reason why my case is certainly a lot stronger than the case in Paul. I think it's been one of the reasons why the courts have been very reluctant to let clinical negligence claims relating to secondary victims succeed, because there's this natural feeling that, well, what if somebody dies 10 years after they were seen by a doctor? Is it fair to impose liability on that doctor for that sort of time frame? So in a sense, it's a floodgates argument, and it's a public policy argument that leads to people thinking that somehow it's wrong to allow claims to succeed where there is a big delay between the breach of duty and the consequences of that breach of duty. But I think the reality is, when you have primary victims, you can have quite a significant delay between the breach of duty and then the consequences of that breach of duty. And whilst there is an argument that things should be tighter for secondary victims, that's a difficult one to see where you could put a sensible cut-off point. And the reality is that a delay of, say, 10 years is rarely, if ever, going to happen in practice. We don't usually see it in primary victim claims arising out of clinical negligence. So there's no reason then why we would see it more frequently in secondary victim claims. If anything, you're going to see it less frequently. So I don't think that there should be a long stop in terms of when claims can, how much of a delay claims can succeed with. I think that would be quite wrong. But it will be interesting to see how the Court of Appeal grapples with that if it comes to hear the case of Paul. And that's one of the reasons why I think it'll be very useful for my case to be before the Court of Appeal at the same time, because there is that distinction between 56 hours and 14 months. I think when the gap is 56 hours, it feels an awful lot more comfortable to say that the tortfeasor should be liable for the consequences to the secondary victim.
Yeah. Well, fingers crossed and best of luck for your case, Esther. Thank you very much for talking to us today. That's been enormously interesting, and I'm sure you'll update us when you eventually find out what's happening with your case. Thank you very much.
Absolutely. Look out for another vlog from us once things have progressed further and we know what's going on with Paul and know a bit more about how my case will conclude. Thank you ever so much for your time today, Rebecca.
Thank you.